Can you tell us about Miss Neto and what actually happened?
Miss Neto is a 37-year-old woman who was diagnosed with bipolar disorder at the age of 15 and since then has been on lithium mood stabilizers for most of her life. In January of 2003, Miss Neto voluntarily admitted herself to the Center for Addiction and Mental Health in Toronto. She ended up in emergency and eventually was placed in Dr. Klukach's care. Dr. Klukach prescribed antipsychotic medications for Miss Neto, but she refused. The doctor then declared her incapable to make the decision on the basis that she wouldn't admit she had bipolar disorder or that she was manic. This is the case of Neto v. Klukach in 2004 in the Ontario Supreme Court of Justice.
So once she refused, what happened next?
Miss Neto took this case to the Consent and Capacity Board, the CCB, which reviews capacity findings and establishes whether individuals are incapable of making a specific decision or not. The board sided with the doctor, saying that Miss Neto wouldn't appreciate the consequences of her decision, although the board did agree that she could understand the information. Miss Neto appealed that decision to the Ontario Superior Court.
What did the court decide and how did they get to that conclusion?
The court overturned the CCB. They ruled in Miss Neto's favor. Based on Section 4 of the Healthcare Consent Act, which governs consent to treatment in Ontario, Miss Neto was found to have fulfilled the requirements of the ability to understand and the ability to appreciate surrounding her condition and treatment. The court examined 3 factors of which Miss Neto passed. The first is that she is able to acknowledge her condition. She doesn't necessarily need to agree with the diagnosis, but Miss Neto was aware that she was different. Miss Neto was also able to weigh the options and consider what would happen if she abstained from the treatment. Finally, Miss Neto was not found to be deciding based on delusion. Her delusional beliefs were unrelated to her decision to refuse the medication. Essentially, the CCB was wrong to consider the situation by thinking about what's best for Miss Neto, since their job is just to assess capacity, not override decisions.
How could this impact future patients on a personal level?
Doctors in Ontario do have the legal power to declare you incapable and remove your right to make treatment decisions. This is true. This case, however, outlines where that power ends. Refusing medication or disagreeing with your doctor does not make you incapable. This is especially significant for people who suffer from or know people with mental illness because of the risk that non-compliance gets mislabeled as incapacity. This case also shows that you have the right to challenge a capacity finding. The CCB exists for this very reason, and there are even courts above that. Neto used this system and won. Your lived experience of your illness and your treatment matters legally. The court explicitly said that the board was wrong to dismiss her experiences because of her mental illness.
What does this mean for healthcare as a whole?
What's clear is that incapacity findings cannot function as a tool for managing patients who won't comply. This case forces clinicians to conduct capacity assessments instead of relying on outward behavior alone. It also sharpens the CCB's mandates, ensuring that they are actually assessing capacity rather than substituting their judgment for the patient's. The broader tension of how to protect vulnerable people with mental illnesses while also respecting their autonomy is shown to not be mutually exclusive through this case. Having a mental illness does not mean that you lose the rights to make decisions about your own body. The law presumes you are capable, and Neto's case proved that presumption means something.